Let's get started. Welcome, everyone. I'm Melanie Cammett, Director of the Weatherhead Center and faculty member of the Government Department. And I'm really delighted to host our visiting speaker today, who's coming to speak both as part of the Global Scholars Network on Identity and Conflict, which is a collaborative initiative between Queen's University Belfast and the Weatherhead Center at Harvard with global partners. That works on research, policy relevant and scholarly research on questions related to conflict, ethnic politics, and related issues. And so we have a colleague from Queen's University in Belfast here with us today, Professor Kieran McAvoy, who is the Senator George J. Mitchell Chair of Peace, Security, and Justice, and Professor of Law and Transitional Justice at the Mitchell Institute for Global Peace at Queen's University Belfast. He has a lot of accolades, so I'm going to abridge it and encourage you to look online. But let me say a few. One is that he's a fellow of the British Academy, actually it's more than one, a member of the Royal Irish Academy, a fellow of the Academy of Social Sciences, and is currently a Leverhulme Major Research Fellow, working on a project on apologies, political violence, and dealing with the past. So I suspect we'll learn something about that today. He has conducted research in over a dozen conflict-affected or transitional countries. The list is really quite impressive around the globe, and he's written about a variety of topics and has authored or co-authored 4 books, co-edited 8 books or special issues, produced a 4-volume handbook of transitional justice, and authored over 70 journal articles and book chapters. His research has garnered so many awards that I'm not even going to list them. And he's held a variety of visiting professor positions in different locations in the UK, in the US, and so forth. So we are really delighted to have Professor McAvoy here with us today, and I will turn it over to you. He's going to field his own question.
Yeah. Melanie, thanks a million, and thanks to you and your colleagues for hosting me here. It's a great honour and a privilege to be here at the Weatherhead Centre. So I'm talking about armed groups and getting armed groups to step up and take responsibility for past harms as part of addressing the past. The background, so I'm a lawyer and a criminologist. I used to say I'm a recovering lawyer, but actually I've become more enthusiastic about being a lawyer in recent years, actually, for reasons that may become apparent. I've done a couple of pieces of work on the topic I'm going to talk about today for the UN. I did a report for the UN Special Rapporteur on Transitional Justice in 2019 on the role of apologies in addressing the past, and more recently a separate one on armed groups and addressing the past. As Melanie said, I've done quite a lot of comparative work over the years, including on this topic, on armed groups stepping up. And I've been working at home in Northern Ireland on and off on armed group stuff for about 30 years, with quite a lot of practical experience actually of engaging with armed groups around peacemaking work, and more in the last probably 10 or 15 years on legacy and addressing the past. I'll talk more about that in a minute. So I pitched a grant proposal to the Leverhulme Trust at home, basically saying I'm sitting on a load of data, and I need some space to write it up. And so they give me this 3-year fellowship to write it up, and I'm about halfway through. And part of the pitch was that I would road test my ideas. So here I am in Boston, I'm road testing away here. And last year I was in New York doing the same thing. So there'll be at least 1 book coming out of this, possibly 2 actually, I think. But also I'm quite involved in hands-on work at the moment, trying to get the British and Irish government, to help the British and Irish governments to frame this issue as to how we can get information, apologies and acknowledgement and truth from Republican organisations like the IRA or some of the loyalist groupings, and I'll talk more about that. So it's practical and academic, basically. So the field that I work in is called transitional justice. Transitional justice, as you'll be aware, is the field about how post-conflict or post-authoritarian states address past harms. The kinds of things that we do in transitional justice include prosecutions, sometimes referred to as the justice option. We focus a lot on truth recovery, on truth commissions. I'll talk a bit more about that, or other forms of truth recovery, on reparations, And probably the least developed, actually, of the pillars of transitional justice is a guarantee of non-recurrence, using mechanisms to address the past that prevent violence or human rights violations happening again. Historically, the field has been quite state-centric. Understandably, it emerges from, in broad terms, from political science and from the human rights movement, and so there's an understandable focus on holding state actors accountable for past violations. States are the signatories to human rights treaties, obviously. But I think in recent years there has been an acceptance and acknowledgement that, well, the state actors are also, the non-state actors are also very important. They're involved in human rights violations. The Red Cross estimates there's 600 armed groups active at the moment, 100 of those in non-international conflicts. And there's dozens of armed groups involved in doing addressing the past transitional justice type work, but it's not written up as such. So anyway, that's what I'm doing basically, is trying to fill that lacuna, focused on armed groups. So moving away from a state centricity towards finding innovative ways to get armed groups to address past harms. I've done a huge literature review on this. I'm not doing any posh theory today, by the way. Mainly because I'm not very good at posh theory, if I'm honest, but I'm sitting on a ton. I have a 200-page literature review on armed groups, political violence, how armed groups think, anthropology of armed groups, military sociology, blah, blah, all that. There's a lot of it, there's tons of it, but I'm not going to talk about that today. So just, you just have to take my word that it does exist. So how do we get armed groups to address the past? Obviously, we prosecute them. We in the transitional justice field, what tends to happen is a focus upon prosecutions is usually around those who are deemed most responsible for past violations. The leaders rather than the foot soldiers tends to be the approach of prosecutors. Amnesties have been an important feature in terms of how you engage with armed groups. It's very controversial. It's been very controversial in the Irish context, as I'll explain in a moment. But it's an important part of the toolkit of how you get armed groups to step forward. I'll talk a little bit in a moment about armed groups involved in truth recovery, not just with state-like mechanisms, like a truth commission, but actually in some instances armed groups doing their own versions of truth recovery, which has understandable methodological and ethical issues if it's an armed group telling their own version of their own past history. There are fairly obvious challenges, but it's not uninteresting. Armed groups engaged in reparative work, in reparations, we did a big comparative project on reparations, and part of that was about reframing reparations as more than just financial compensation, but seeing reparations in a broader terms. We were drawing in particular on restorative justice. Armed groups and apologies, and then I'll finish up. So there's a big legal framework. This is the justice stuff. There's a big legal framework for addressing past violations by armed groups, laws of war, international humanitarian law, human rights law, the international criminal law, and so forth. Lots of law is central in the design often of how you approach justice issues concerning armed groups. It's also the toolkit for the design of all bits of transitional justice, because whatever you're doing has to be lawful. It has to be legal. So as I say, I used to be very funny. I was in the room down below, the Judith Sklar room, and probably the most famous thing I've ever written is called Beyond Legalism, and it's 20 years ago, and it's me beating up on lawyers and the hubris and arrogance of lawyers in transitional justice, and I was pretty hardcore on that line, and so her work on legalism was very influential on me. I'm gentler on lawyers nowadays. I'm 58, and partially it's what's happening in the world, where you sort of think. I remember, for example, I was doing a talk on beating up on lawyers, and a very senior solicitor from home, a lawyer from home, and like if beating up on lawyers goes down well with the crowd at home, generally goes down well anywhere, but he was there, and so I'd finished up beating on lawyers, and then he cut in. His name was Peter Madden, and he cut in at the end. He goes, "Kieran, lots of people give lawyers a hard time, and everybody does that until you need one." It's very true. So in the way that the world has gone, actually, lawyers stepping up has become increasingly important. Lawyers taking ownership of ethical and moral responsibilities of what it means to be a professional. The last book I did was with two colleagues, was an exploration of the role that lawyers play in conflicted and authoritarian contexts. And anyway, so all that to say, law matters, lawyers matter, and I'm less anti-lawyer than I used to be. The big challenge, so anything you're doing in transitional does have to be legal, obviously, and there are legal standards around what you can and can't do, as I'll explain in a moment, for example, with regard to amnesties or immunity from prosecution. But the question, the balancing act that societies post-conflict are often facing is, can you get information, can you get truth from armed groups if you have the threat of prosecution hanging over people? How do you strike that balance? And that's been a significant challenge in our own context. I've done a couple of big projects on amnesties per se, and I'll summarise. One of them was 3 years of work. I'll summarise it now in about 45 seconds. Amnesties are a negation of criminal or civil liability. That's what they are. Sometimes in the literature on amnesties, people talk about amnesia and a focus on forgetting. That is not what amnesties are about. They are a negation of criminal and civil liability. Historically, amnesties tended to be blanket in nature. In other words, a state had a fairly untrammeled discretion as to what it could or could not include in an amnesty. But in international law, what has been happening in the last 60, 70 years has been a narrowing of what states can and can't do. So, for example, it's no longer lawful under international law to have amnesties that include war crimes or crimes against humanity. So what's been happening, and you've seen this particularly in the inter-American court system, where the courts have been narrowing the discretion that is available. So former authoritarian regimes, former dictatorships like Chile, Argentina, Brazil, the courts have been finding previous amnesties, which were tended to be blanket in nature, introduced by the authoritarian regime, finding them to be unlawful, basically, and people have been prosecuted. There's over 200 people have gone to prison now who were affiliated with the Pinochet regime in Chile, for example, because the amnesty that he'd introduced has been eaten away at by the courts. And so if you think in broad legal terms, that's what's been happening, is that it is still viable to design lawful amnesties or immunities, but it's trammeled by certain conditions around humanitarian law and crimes against humanity, genocide, and so forth. And in particular, in the European system, which is governed by the European Convention on Human Rights, we call it the right to an effective investigation. In the inter-American system, they talk about the right to truth. It's the same thing, basically. It's about the ways in which the state's obligation to provide families who've been affected by conflict or violence cannot be obviated by an amnesty, right? So if you're sitting down to design an amnesty, what you have to bear in mind is that is this going to cut across a family's right to get to the truth? And if it does, it's unlawful. And so what happened in the British context, you may be aware, is that Boris Johnson introduced an amnesty for British soldiers who served, first of all, in Iraq and Afghanistan, and then secondly, in the Northern Ireland conflict. He introduced a fairly obnoxious amnesty. We have a database at Queen's of every amnesty that's been introduced in the world since 1945. My colleague Louise Mallender did the work as part of her doctoral work. And so we have every amnesty, and so 540 amnesties in that database. And so when Boris Johnson introduced this is now, bear in mind, he introduces this amnesty in 2020, a long time after the Irish conflict is over. The Irish conflict ended in 1998, realistically. So it's 22 years later, he's introduced this, and we were able to show to the media that this was worse than Pinochet. So Boris Johnson's amnesty was worse than Pinochet's, which caught on, as you can imagine, in the media. So anyway, he was introducing an amnesty that was legally obnoxious. Ultimately, it was rejected by the courts, and Weatherhead played a role, actually, in that, which we can get into in discussion. So that has been found to be unlawful in the courts, in the Northern Ireland courts. It's very, very helpful. And we're now in the business of, so the new Labour government has been elected. They said that they were planning to get rid of Boris Johnson's amnesty, and so they have done that. That's happening, and now we're trying to work out what does it look like. How do we redesign it? So I spent the last 4 years basically beating up on Boris Johnson, beating up on that amnesty, and that's gone. The courts have now accepted. And now what I'm doing is saying, okay, that amnesty's gone. However, we do need to find some mechanism that will allow armed groups to provide information to families. And so what we need to do is to look and find creative ways in which we can find limited immunity that will not cut across families' right to an effective investigation. Okay, so it's having been anti-amnesty very loudly in public at home for the last 4 years. Now I'm kind of okay, now we have to go. I had a meeting with the Secretary of State, who is the British government's representative. Basically, he's our proconsul. He runs the place. Well, he runs the place for reserve matters. The Devolved Assembly runs it for other matters. But anyway, and so when he was in opposition, I would have been saying, like others, that Boris Johnson's amnesty was obnoxious. And so, not understandably, he's now saying, okay, so that amnesty was bad, but you think we need to have something else. Yes, we do. Because otherwise no one's going to come forward unless we have some form of limited immunity. And it's finding the balance in terms of that. Okay. So there's been 50 odd truth commissions around the world. Probably the best known is the South African Truth and Reconciliation Commission. The way in which that commission worked was you had a human rights violations committee, which it's all chaired by Archbishop Desmond Tutu. And it does the work of truth recovery, right? So they have public hearings, they have researchers, they're involved in crafting the narrative of what happened during the apartheid era. That's one bit, the more famous bit of the South African Truth and Reconciliation process. Separate to that, parallel to that, they had an amnesty mechanism built into the South African Truth and Reconciliation Commission as well. Now, that was a highly legalistic process. It was, from my perspective, quite an effective one. It was judges who made the decisions whether or not a person should be granted an amnesty. The families who were there at the decision making, so these were public hearings as well, families who were affected, so the victims' families were legally represented as well as the perpetrators were legally represented. These were in public. But the legal criteria for the granting of an amnesty by the South African Truth and Reconciliation Commission was, number one, it had to be affiliated it had to be relevant to the conflict. So a lot of ordinary prisoners applied, saying, oh, my crimes were really motivated by what was happening in the apartheid. And so they had a fairly strict definition as to what was or was not a political offence, and therefore was relevant for the. But secondly, it required anyone coming forward to give full disclosure in terms of providing information as to what human rights violations they had been directly involved in. And so 2/3 of people got knocked back. More than 2/3 of people got knocked back, got refused, because they didn't meet the criteria. So the judges were taking quite a legalistic view of, have you given full disclosure of what you were involved in? And if the lawyers from the other side, from the victims, could demonstrate you're not giving full disclosure, then your amnesty application was rejected, or if it was determined not to be relevant to the conflict. So, for example, the police officers who tortured Steve Biko to death, very prominent person you may have heard of, they continued to hold the same lines of lies that they held during the apartheid era, that he slipped on a bar of soap, fell over down the steps, blah, blah, blah. And so the judges rejected it. So their amnesty application was rejected. And we interviewed some of the lawyers actually who were involved in those hearings, and they were saying, like the one lawyer who I'm thinking of in particular, who represented a lot of security force personnel, said, I just read the law. So I said to my clients, tell every dirty deed that you did, because if you read the law says full disclosure. If you give full disclosure, you can't be knocked back, right? So it was legalistic but effective. Probably that's the best known. The Colombian mechanisms are probably some of you may be familiar with. So more recently, as a result of negotiations between the then Colombian government and FARC, we've had a range of very interesting transitional justice mechanisms established in Colombia. So there's a truth commission in Colombia. There's a prosecutorial mechanism called the HEP, JEP, which can give reduced sentences to people if they go through a range of things. There's a big reparations program, the most ambitious reparations program in the world in Colombia. I think there's now 12 million people eligible for reparations. And there's a process to return the people who were disappeared during the conflict. But part of the process there, interestingly enough, is that the HEP can compel an armed group to apologise for past violations. So, for example, FARC, as you'll be aware, were involved in a tactic of kidnapping people in order to raise funds for the struggle. And they were doing this on an industrial scale. Now, kidnapping is an international crime. And so when FARC were found guilty of that international crime, the court, the HEP in Colombia, determined that they should offer an apology as part of addressing the past. Now, people are also, there's other things that they were, but an apology was part of the formal sanction. Okay. So these are top-down transitional justice processes where people are trying to engage with different ways of engaging with armed groups. There are other bottom-up initiatives. This is a thing, I think I sent some readings to you. Don't worry, I don't expect anybody to read anything. But we have had experiences at home of different styles of bottom-up and top-down transitional justice. This was a bottom-up Transitional Justice Initiative, which I was involved with, where basically we held an event at Queen's where a number of people were on a panel, myself, the Chief Constable, a senior Republican, a senior Loyalist. Place was packed. There's a man puts his hand up from the crowd who says to the senior Loyalist, your organisation killed my father in 1974. I'm not interested in prosecutions, but I am interested in information. I want to know why he was targeted. I want to know a range of things. The person who's representing the Loyalist group is too young, and he said, I don't know your case. So he definitely wasn't around, obviously, but if I can help, I will. So what happens then is a from below process of engagement between the person who was on that panel, who became an interlocutor in the process, seeking information, and the victim, and then the request then going into the armed group seeking information. Now this family had all of the things that the formal justice system could deliver. So there had been an original police investigation. One person had gone to jail as a result of the murder. Only one. There was probably up to 40 people involved in this murder, but only one, in terms of logistics, providing cars, all kinds of stuff. But one person had served a life sentence for it. There had been an inquest, which is in the UK legal system, if there's a controversial death, then a judge has to oversee a kind of, I don't know if it works the same in the States, but anyway, that's we call it an inquest, a coronial inquest. Coroner does this, but it's a judge. There had been an investigation into the police investigation, because there was an allegation of collusion between the organisation responsible and the police. Anyway, all of the formal stuff had been done that it could be done. But the only people who could provide the information to this man that he and his family wanted was the organisation responsible for the killing, right? And so what happens then is, after a lengthy process of about 18 months' work, they asked me if I would help in the process and write up the report basically on what they had done. And long story short, as far the victim is provided with exactly what he wanted. After a long process of negotiation, he gets a report. The organisation had never admitted responsibility for this killing, partially because they were on ceasefire at the time, and so this was a breach of their own ceasefire. Anyway, he gets what he wanted. He gets the information, particular information that he wants. He gets a formal statement of acknowledgement and apology from the organisation. So it delivered. So this was a bottom-up process. Now, this, for the organisation in question, this was a proof of concept piece of work, demonstrating that they had the political will and the capacity to deliver on this kind of work. Sure.
Sorry, on the previous slide,
Yep.
when you're talking about how the process delivers, there's something about confirmation of innocence. Did that refer to?
It will have been about, there were allegations made at the time that the person, that the father involved had been a member of the IRA and therefore was a legitimate target. That was a lie, but that was one of the things that they accepted was the innocence. Basically, he was a civilian, he was targeted. It was a complicated case, but he was targeted because he was a Catholic, basically, and because someone wanted him targeted. But that confirmation of innocence was the allegation that he'd been a member of the IRA was not true, basically, which would have been used to rationalise his killing then, of course. So another prominent example, some of you may have seen Say Nothing. You've seen Say Nothing TV show about this? Yeah. So anyway, another interesting initiative, this is a top-down initiative. So I've shown you one bottom-up initiative, armed group engagement. This is a top-down initiative of armed group engagement in terms of addressing the past. In the Irish context, one of the a tactic that emerged on the part of the IRA in the 1970s in particular was that people who were alleged to be informers, so that the penalty for informing was usually execution. Not universally, but usually execution, although they also used amnesties at different junctures. But anyway, broadly, the penalty for being involved in providing information to security forces was death. But in a number of cases, not only did the IRA and one other Republican group, kill people, so they would kidnap people, they would interrogate, torture them, they would get the information that they find out the information that had been provided, what had been compromised, but in a number of instances they also disappeared the bodies. They didn't give the bodies back to the families. So in the Irish Catholic tradition, the tradition of burial is really important for families. So these families who were affected by this wanted the remains of their loved ones back. And so there was an agreement, and after the Good Friday Agreement was signed, the British and Irish governments established a cross-border mechanism, a jurisdiction operating on both sides of the border, to help recover these bodies. Now, the way in which that legislation is very clever legislation, the way in which that legislation was framed, no information provided to that body could be used for prosecutorial purposes, right? But it's not quite an amnesty, because what it's saying is, so basically that meant there were no forensics carried out on the bodies, no forensics carried out on the grave sites, so nothing could be done. The normal detective work that you would do recovering a body, none of that could be done. But if information came from another source, a police investigation over here, separate from that, then the prosecution could go ahead. That was the deal. It was a limited form of immunity. Only within that mechanism could. So it has broadly been a very successful piece of work. So now it's been highly complex technical work, and it's a secretive process. But so the two governments established this cross-border body. It was led up until recently by a retired detective, a British detective, and he established relationships of credibility and trust with the armed groups who are responsible for this. So that the only way practically that this works is that people as I say, it's a highly secret process. So I'm surmising here, but I have said this in various places, and no one's contradicted me who were in the room who would know. The only way this works is that at least people involved in the burial details, so people would have been buried in forests, in mountains, in bogs, at the dark of night, sometimes 40, 50 years ago. The only way that it works is that you have to bring back people, at least who were involved in the burial detail, back onto site. So this means you have IRA members wandering around forests and bogs with a retired British police officer, seeing if they can remember where a body was, and then of course you deploy all the tech stuff to try to find the remains. That's an incredible relationship of trust that has been established there, and it's to the credit of that body. So they have they've recovered 14 bodies to date out of 17. One, Jean McConville, who's probably the most well known, actually was recovered by accident. Her body washed up off the coast of Louth. But the rest were done as a result of engagement between Republicans, between the IRA in most of the cases, and this body that was created. So this is an example of a successful top-down transitional justice mechanism that has worked. It has not only worked in the Irish context, this is the miracle of this piece of work, right? In one case, the INLA, which is a small splinter Republican organization, was responsible for killing a person who was affiliated to the political wing of that organization and burying outside Paris, about 100 kilometers outside Paris, right? I don't know if you've ever had any experience of dealing with French bureaucracy, but can you imagine the discussions that took place where they would have had to go to the French gendarmerie and to the French judiciary and say, we have this thing in Ireland where there's been a murder, but you're not allowed to do any forensics and you're not allowed to do any investigations. Can we transplant our model? Oh yes, and we're probably going to be bringing over some of the people who were involved in the actual original. Now that took place, there's a play in that, and they found the body. It's a remarkable piece of work, So anyway, that's it. It can be done. This is just another example of armed group reparative work. I'll finish in the next couple of minutes because I want to give space for chatting. One of the things we were very interested in Colombia when we were doing our field work there was processes of demining. So FARC basically deployed a strategy of, in order to try to retain control over territory, particularly out in jungle areas, they put down hundreds of thousands of landmines to make it difficult for the state forces to get into their areas. And so what's happening as part of the peace process now in Colombia is that FARC members themselves are involved in the demining, overseen by the Colombian army. So you'll see that quote there, that's from a Colombian brigadier they're framing this as reparations. This is a practical and symbolic act on the part of the armed group, digging up mines and doing it under the supervision of the Colombian armed forces. I'll talk a wee bit about apologies now. So I say I've done a lot of work on apologies. Melanie's saying there about she's starting a new survey. The last project I did with colleagues on apologies, we did a lot. We had all singing, all dancing methodologies. We were interviewing, so it was apologies across three sectors: the conflict, institutional child abuse, and the banking crisis. So we interviewed apologizers. So we interviewed Republicans, loyalists. I interviewed David Cameron, who did a very famous apology for Bloody Sunday, former British Prime Minister. We interviewed victims. We did focus groups with victims. We did focus groups with the general public. And we did a survey across the island of Ireland. Cost 30 grand to do that survey. And our hearts were in our mouths because basically we were asking, do apologies matter? And if the people of Ireland had come back and said, not really, that would have been a very expensive, it would have been scientifically rigorous, but it would have been a very expensive failure. Anyway, 72% of the people of Ireland thought apologies are really important. Thank God, right? And it was up there, it was just below truth and justice, so it was kind of great. We thought anything above 65, we can claim that as a success. 30 grand confirmed to us that the people of Ireland think apologies matter. So in our all singing, all dancing methodology, we got some interesting stuff from our fieldwork. This is an example here. This is a guy who used to be the officer commanding in the Maze prison. So he had the leader of the IRA within the prison, talking about the reasons for apologising. And he's talking here about apology being a moral act as well as a political act. The thing that I thought was really quite interesting as well is his appreciation for, if you are offering an apology to those you have hurt, you cannot do it in expectation of any generosity from victims. You're doing it because it's the right thing to do, but do not be expecting forgiveness, don't be expecting anything. You're doing this as a military or political movement because it's the right thing to do, morally and politically, and do not do it in expectation of any reciprocity. This is probably the most famous IRA apology. I have a database of every apology that's been introduced in the conflict since 1970. There's over 500 apologies in it. I'll use a very scientific term. Some of them are shit. Like the early 70s apologies are things like, they say they've accidentally killed a civilian or something. It's like, we are really sorry we killed a civilian, but it is the fault of the British who are occupying our country. That is not really an apology. Anyway, but we see a maturation actually in the use of language over, particularly into the transition phase. So this is this is an example of, this is the most famous IRA apology. So in 2002, 30 years after a particularly horrendous series of bombings in Belfast, where there were mass civilian casualties, the IRA issued this apology. It's an interesting one. It got a lot of positive feedback at the time. It was introduced, as I say, on the anniversary of the event, but also at a time when the politics was quite frozen, and it was, I think, deliberately deployed by the then Labour government and the Irish government in order to try to facilitate an impasse that had arisen around decommissioning with the Unionists. So it was very political. So you see it, they're maintaining a distinction here between civilians and combatants, right, which is quite important. But they're going on to acknowledge the grief and pain of their relatives. One thing that is absolutely central for all actors in our conflict and in most conflicts is that all of them think that at least some of their past actions were legitimate. They are not going to disavow the armed struggle, loyalists or Republicans or state actors. All of them think that some of what they did was legitimate. So the question then becomes, how do you square that circle? If you're not disavowing the armed struggle per se, how do you apologize for past actions? So what they would have done here is make a distinction between civilian casualties and combatants, right? And you use slightly different words. I think they would go much further now. I think a lot of us have been arguing with Republicans and others that if you're going to make a distinction, I'll frame it this way. A statement of apology is not the place where you restate your belief in the legitimacy of armed struggle. It is about addressing the needs and wants of victims. So even though you think that at least some of your past actions were legitimate, this is not the place to say it. Say that somewhere else. I'll give you an example of this is an interesting apology. So this is the NLA, the group who killed the guy in France. So this is our ceasefire statement, which also included an apology. Innocent people were injured, and at times our actions as a liberation army fell far short of what they should have been. For this, we as Republicans, Socialists, Revolutionaries offer sincere, heartfelt and genuine apology. Okay. We have, however, nothing to apologise for in taking the war to the British and their loyalist henchmen. Now, I suspect if any of you had been advising the INLA Army Council in the drafting of this, you'd say, you know what, lads and lassies, I would drop the last bit. The last bit just doesn't ring as well, you know. So anyway, that's a good example of a bad apology. I'll finish it. I'll just show you one more loyalist one. This is the most famous apology. This is the apology that came from the loyalist groups, and the language was really interesting. I can't remember if I sent you a copy of a paper. I'd done a paper on this where I just nerded the life out of this one statement. I had a proper 15,000 word nerding, you know. So on the history of it and the afterlife of that particular statement, the language of abject and true remorse, right? That when we did the surveys, the survey work with the public around the island of Ireland, this is the one everybody remembers, the loyalist one, abject and true remorse. Nope, it has what PR people would say is stickability. Yes.
They remember it in a good way, or
No, in a good way and positive, yeah. I mean, partially in a way, partially because it was the IRA when they issued their ceasefire statement didn't apologise at all. So that one theirs came. So their ceasefire is 1994. The big apology comes 8 years later. Loyalists were first in there. The language was good. Also, there's a lovely anthropology called seeing like a state, you know, which you know that Jim, come back, yeah, exactly. So there's a version. My effort at Poy's theory was to see this from loyalists. So loyalists were taken seriously at that stage of the peace process. They've always struggled with public relations wise, and this was it was performative in that sense, and it worked basically. You know, they were taking it seriously and being taken seriously, and doing that in a very public way, and so they got a lot of kudos actually for it. Now, because a lot of some loyalists have got involved in drug dealing and distribution and criminality, they have significant PR problems, which is why actually that other piece of work I talked about, the From Below thing, was probably the first positive PR that group, the UVF, has had in 20 years. So anyway, this is Martin McGuinness, sadly now passed, former IRA leader, former Deputy First Minister. McGuinness was an IRA leader, and he was out there as an IRA leader, and therefore he had credibility. And often you can see in his line, I've tracked all of his apologies, he goes further than a lot of former IRA people have, because no one could ever have said he didn't wear the boots. You know, no one could ever question his credibility or commitment, either to the armed struggle when it was on, or to the peace process afterwards. So he can go further, and the way he frames it as well as non-recurrence is quite effective. Okay. So I did a big schema. It's in your papers there. I'm not going to go through all of this. So this is the thing I did for the UN. This is what an effective apology is supposed to include. We can talk about that in the Q&A. Anyway, it's there in your papers. I'll finish up on this. So the intersection between apologies and all of this, I think what we're trying to get to at the moment in the Northern Ireland context, and perhaps more broadly, is number one, finding ways in which we can get information from armed groups, finding that balance between accountability, prosecutions, and limited forms of immunity that allows them to provide information to those that they have hurt, encouraging them to engage in statements of apology or acknowledgement, but also seeing this is not some soft alternative to, you know, human rights compliant effective investigations or prosecutions. Prosecutions remain on the table in the Northern Ireland context for the moment, although no one prosecuted can serve more than 2 years. Under the terms of the Good Friday Agreement, all prisoners were released within 2 years, and the court subsequently interpreted that to mean that anyone convicted of a conflict-related offence up to 1998, regardless of its seriousness, would only serve a maximum of 2 years. The legal power already exists to move that to 0, and I think that's where we'll end up going. So in conclusion, trying to think through how you engage with armed groups in transitional justice, it requires obviously political will on the part of the armed group, but also capacity. Some of our armed groups have morphed into criminal gangs, and therefore you have to be fairly cold-eyed about the particular group you're dealing with and whether or not you're going to get anything of quality from them. I'm okay, I'm quite relaxed about law being a stick in terms of prosecutions. But also I think that we need to figure out clever and creative ways to use law to frame lawful versions of limited immunity. In engaging with armed groups, part of what you're trying to do is to get to see what aspects of their political ideology will resonate in doing the right thing. You know, notions of honour, for example, military honour. is quite useful actually, in terms of tickling the funny bone of an armed group. Finding out what it is about their self-image, how they regard themselves, how they regard their struggle, and see if you can adapt a kind of nuanced grasp of their politics. So obviously, because I'm working on it a long time, I would have a decent feel, I think, for the politics and ideology of republicanism and probably loyalism as well. But it's about taking that kind of nuanced feel of the organizational sense of self and seeing if you can tweak that. It requires credible interlocutors. The disappeared process worked because the interlocutors were good, because the commission was very smart in the way it did its work. The Crawford process, again, the interlocutor in that case also, as far as the victim is concerned, did his job very effectively. Victims have to have confidence and trust in whatever process you're using. And so what we would always stress in this context is that if, for example, you're talking about information recovery from armed groups, it's only for victims who want that. Some victims will say, I don't want to touch that process that involves those people that killed my loved ones at all. That's totally fine. Of course, it's choice, basically. That's the choice. And all of this, if we do this in our context, this is the last bit of the jigsaw in terms of our peace process. It has dragged on. Like, we had Good Friday Agreement in 1998, but this is it, and this is what a peaceful future looks like. Okay, thank you all very much.
So we have plenty of time for questions. Let's open it up. I have a ton of questions, but I don't want to monopolize here. So if anyone else would like to go first. Yes, Oded. And maybe introduce yourself if you don't mind.
I'm Oded Tafai. I'm a building scholar at the Weatherhead Center. Thank you very much. This is really interesting. There's a lot there. And I've actually got a lot of questions, but I'm probably gonna settle for two. So the first one relates to sort of the sequence where this comes into place. So on the one hand, it seems that sequentially, for the kind of trust that's required for this, you already kind of need peace in place, or a degree of peace. But on the other hand, for many of the victims, it may be a precondition for peace, the willingness. So how do you sort of resolve that issue? Then I want to sort of ask you about the apologies part in particular, and what you refer to as a bad apology. So it seems to me that if the audience for the apology are the victims, you're obviously right, like there are no caveats, there should be no caveats. But potentially the audience for a proper apology is also the domestic audience, your constituency on behalf of in Europe. And therefore that caveat might actually be necessary. Those caveats might be necessary to make it palatable for them and to prevent recurrence.
Yep.
So I guess that's not really a question, that's a thought. But
No, it's an excellent thought. Do you want me to come back on these or?
Whatever.
Okay. Yeah, because they're big. So sequencing, you're absolutely right. Central to all of this. In our context, I mean, there are people in my field who are working on transitional justice while conflict is ongoing. I have a colleague who's an Israeli colleague who thinks that you can do transitional justice while conflict is ongoing. I think that's tricky. But in our context, it wasn't, none of this would have been viable, I think, in the white heat of conflict. So the disappeared work could only happen after the ceasefires, after the agreement had been concluded. We weren't, during the negotiations actually of the Good Friday Agreement, I've gone back and I've asked Senator Mitchell about this. In a lot of peace processes, part of the negotiations are actually about legacy mechanisms. So for South Africa, for example, the negotiations around the Truth and Reconciliation Commission were central to the overall political negotiations. Similarly in Colombia, so addressing the past is now part of what you do when you're negotiating peace agreements. When I've talked to the senator himself who chaired our negotiations or political actors who were around at the time, all of them say we weren't ready at that stage. It was already difficult enough for us to get a deal over the line. If we tried to come up with a consensual mechanism on addressing the past, we would not have had a Good Friday Agreement. So your sequencing point is absolutely central. We weren't ready. Now, it should not have taken us till now, like to 2025. We're still trying to agree legacy mechanisms. What happened in our case was that the criminal justice system in effect carried a lot of the weight. So we had individual investigations into cases. We had lots of different legal mechanisms. So, but that's a collective failure in terms of our politics. But we weren't ready to do transitional justice until afterwards. So, and you would not have got apologies out of armed groups. You had self-serving apologies during the conflict, but the kind of more generous, more thoughtful kind of apologies that can make a contribution towards reconciliation were only possible. And so I think you have to be honest with victims about that. What's viable, and certainly in our particular context, in the white heat of conflict, transitional justice was not viable. But it's a great question. On the audience question, that's another great question. On apologies. You're right. So there's three broad audiences, I think, for apologies in transitional justice. One are victims and survivors, and part of what I didn't labour it there, but part of what is on that schema that we did for the UN is that if you're going to have effective apologies, you should engage with victims first. So one of the reasons David Cameron's apology works well in terms of Bloody Sunday is, so for those of you who don't know, so Bloody Sunday is the British soldiers shoot dead civilians who are there on a civil rights march. There is a big there's a public inquiry initially afterwards, which is a cover-up. Second public inquiry takes a long time, but establishes that all of those killed are completely innocent. And there's a big choreography around it. And Cameron is the relatively new Prime Minister, actually, at the time. And he does this public apology from the House of Commons, because the report is delivered to Parliament, which had commissioned the report. And it's a broadcast on a public screen in Derry where the events happened. It's a big, thousands of people are there. It's hairs in the back of your neck kind of moment. I remember very, very clearly. But one of the clever things that Cameron did was he talked to victims first. So his office liaised with the families of Bloody Sunday via a very clever woman. It was her idea within the Northern Ireland office, who got in touch with the Bloody Sunday families and said, look, we don't know what Lord Savile is going to find, but if he finds that actually those who were killed were innocent, and of course everybody knew that's what they were going to find, and if the Prime Minister were to be minded to offer an apology, what would that look like, and what would be important to hear and not hear? So you can clarify issues of language and context and all that. And Cameron did a brilliant job. I mean, I would not be a natural supporter of the Tories, but he did a brilliant job. It was a really good piece of statecraft. So that's one audience, is victims and engaging with victims. Second is, and this is part of that sort of seeing like an armed group, respectabilization. Part of it is other political interlocutors that you're dealing with. It could be other political parties. It could be governments that you're dealing with. We want to be taken seriously as players, if we are transitioning to a political party, all of that. So there's a second broader audience. Sometimes that's referred to as the public, but it's not really. It's the politics, basically, And the third, as you correctly identify, is the base. And this is where it's a really interesting question, because in our context, and in others, so what you don't want is to alienate the base you have to bring your base with you in terms of this. So that's what you see with that IRA apology in 2002. Because what you don't want is the IRA issues a statement, and then the next day you have other prominent individual IRA members saying, what are you apologising for? It's a legitimate war. What are you doing? That becomes even more challenging where, say for example, in the context of Irish republicanism, where the generation of leadership of contemporary Irish republicanism were not in the IRA, right? So you have Mary Lou MacDonald, who's the president of Sinn Féin, and you have Michelle O'Neill, who's the first minister of Northern Ireland. They're the next generation on. Neither of them were involved in armed struggle. Now, in Michelle O'Neill's case, her father and her family were. She wasn't. So what you then are struck with is, can you, as the contemporary representative, apologise for past actions, and particularly in a context where it's so immediate? Because what you don't want, again, is IRA veterans then coming out the next day saying, who are you to apologise on behalf of what we did? You didn't have to do it. We were the ones who had to take up arms. Really challenging, and I think where we've gone to, where we're going maybe on that, is that I think contemporary political leadership of a group that has transitioned from armed group to politics like republicanism, general statements of acknowledgement from the contemporary leaders of that can happen. But if it's if we get to a stage where we're going to have a new Legacy Act, if we have an agreed mechanism for investigations and an agreed process for getting information out of armed groups, if there are particular apologies for particular IRA actions, then there's an argument that it has to have that should come from people who were in the IRA, who wore the boots, as one interviewee suggested it to me. He said you have to have worn the boots, and so for the base for your point. So it's not that. So anyway, that's a very long-winded answer. But those are the three audiences, I think. So thank you. Great questions.
Yeah, my name is John Galante. I'm at the Weatherhead Scholars Program, and historian of Latin America. I was wondering about the potential relationship between state actors and non-state actors engaging in these kinds of activities, transitional justice, apologies. Like, does that help? Could it help? Like, how does it work potentially with state and non-state actors engaging in these things simultaneously? Look, the other side is doing it too. Or is that not, could that be actually prohibitive as well? Like, I just wonder, like, you're talking obviously mostly about non-state actors here, but like, is there ever engagement in that sense, and how, and so forth?
It's another great question. We had one political agreement to set up a range of mechanisms to address the past, called the Stormont House Agreement in 2014. There's a line and a half in the Stormont House Agreement, which says, so we got different mechanisms to do different things. We had an information retrieval mechanism, like I've been suggesting, that was agreed to get information out of armed groups. You had an investigative mechanism, oral history, and another thing on themes and patterns. And this line and a half speaks to your point exactly. And it says, in the context of the work of these other mechanisms, the two governments shall consider statements of acknowledgement and would expect others to do the same. Now that's negotiation speak of every sort. So there was a prior agreement that wasn't completely concluded, where that bit on apologies and acknowledgement was 5 pages, right? And it was all about the sequencing between the state actors and the non-state actors, that you would have a kind of choreography of the British governments, the Irish governments, Republicans, Loyalists, and potentially other actors, the churches, all being involved in a choreography of acknowledgement. But it got down to a line and a half on that. I think we've moved on since that. So where we could be getting to, I'm an optimist on this, is where we have some kind of choreography between the state actors and the non-state actors, where you would have a set of statements coming from the British and Irish, and then the leaders of republicanism and loyalism at least, around if we get agreed legacy mechanisms actually established. So if we get new legislation coming in the autumn, and if that as a mood setter. Now this is really quite interesting, because my own view on this was historically, how can you have apologies until the truth is established? How do you apologize for something unless it's very clear what happened and who's responsible? And so I was presenting this at an event. Well, it's now public knowledge that this event took place. So I was presenting this at an event which involved the British government and the Irish government and Republicans and Loyalists and lots of other people in the victims community. A very mixed audience. But at this event, this question of sequencing came up, and the relationship between state and non-state. And I was thinking, well, hold off, apologies come after truth. But actually, in that conversation, a number of people said, no, we can use this choreography as, we can deploy it as a mood setter. That if, imagine we had agreed set of legacy mechanisms to address the past in Northern Ireland in the spring of 2026. And in the context of the work of those, then you had statements from state and non-state at the same time. We are now all stepping up to own the past. That's what these mechanisms are going to do. Then there's a role for that. I've also tracked the state apologies. There's been a lot of state apologies, and some better than others. Cameron did some very good. Tony Blair has done some. There's a lot of literature actually on state apologies. It's a much more developed theoretical work than, and Boris Johnson's, funny enough, were terrible. He did two, and they were crap. They were very poor. Sorry, I lost you in the scientific terminology again. We apology nerds do that. But they were just, his heart wasn't in it. It was obvious it was just lack of, anyway. But 100% is the answer, that this requires statements of acknowledgement and apology from both the state and non-state actors, and it is possible to see a way where they would be coordinated, I think.
One follow-up statement,
Sure.
I guess. Sorry. just that it's interesting that there's state actors on both sides.
Yeah.
Right? Versus maybe other situations where there would be like state actors on one side and non-state actors on the other without like that intervention of like state actors on
And
one side.
where it gets really interesting as well, John, is that in our context, it's not always clear who's the state and who's the non-state actors. So what about in a context where you have agents within armed groups who are being run by the state? So we had a big investigation in there completed by our now Chief Constable, John Boucher, who's now the Chief of our police. But before that, he was Chief of Police somewhere else, and he came in to do a big investigation. So whereby British intelligence had managed to get a person in place in the IRA's internal security unit. In the number 2, and the IRA had its own internal security unit responsible for finding informers and executing them. And the number 2 person in that, who was responsible for deciding who lived and died within the IRA, was a British agent. So then that report comes out. So this is where's the state responsibility and where's the non-state responsibility. And so interestingly enough, the now Chief Constable, who's a very clever and imaginative man, he in his report, he said, we need apologies from both the state and from Republicans for this, because it's the state the state was clearly involved in making decisions who lived or died in that. Then it has legal, moral and political culpability. Republicans are also responsible, they're the ones pulling the triggers. So it's both. So it's sometimes in these messy conflict zones, where's the state and where's the non-state. So both basically, again, back to the same answer, I think.
Thank you so much, first of all, for that talk. That was great. My name is Yelena. I'm an assistant prof in anthropology at Northeastern. My question is about the relationship between apologies and truth that you were just talking about, but I'm interested from the perspective of victims' families. Do you see in your data at all if having access to the truth of the families that feel like they know what happened versus the ones where maybe the bodies are still missing or they don't have details, do they have different relationships to how they feel about apology? Is that something that you notice?
That's another great question. So I suppose a couple of things. Number one, in a lot of our projects, we've done a lot of interviews with victims. Their views are not monolithic, obviously, and they're not static. So, during the campaign, for example, for Bloody Sunday, a lot of the families focused on, we just want the truth. But actually, after they got the truth and they got the apology, then some families, a minority, said, no, we want prosecutions as well. And they never would have said, they wouldn't have said that 10 or 15 years ago. They would have just said, we want the truth. And that's fine. Why should their views be frozen? On the apology, truth, I was very influenced, my own thoughts on that, by a very prominent victim at home called Geraldine Finucane. So Geraldine's husband was murdered. He was a human rights lawyer, like myself, and he was murdered by loyalists, but at the instructions of the British state, basically. It was a collusion. It's a dirty collusion case, an awful collusion case. So the people involved in the actual murder were British agents. The people involved in providing the weapons were British agents. Police officers were encouraging loyalists to kill him. It's one of the most prominent dirty case. And that family have been campaigning for a public inquiry, a discreet public inquiry into his murder for 3 decades, right? And his wife is the focal point of that. That has now just recently been granted, actually, a public inquiry by the Labour government. So David Cameron appeared that he was going to grant a public inquiry into that case. And so basically an agreement had been reached with the families about setting up a public inquiry, and then families got on a plane to fly to 10 Downing Street from Belfast, and between them getting on the plane in Belfast and getting to London, the British changed their minds. Cameron changed his mind. So the suggestion that was aired in the courts was that the intelligence services got to the Prime Minister and said, you cannot do this, right? So, and he changed his mind. Basically, by the time they got on a plane to go over and formalise the deal. And so then instead what David Cameron offered was a review of the papers, rather than a public inquiry. Obviously is a judge-led inquiry where you can cross-examine people, you see everything, see all the intelligence. A review of the papers is a review of the papers. So what was offered then was a review of the papers. And so the family rejected that. But at the time, one of the interesting things was, so Cameron does a very fulsome apology to the review of the papers report that came out. It's actually an interesting report. It's called the Silver Report. And so he apologises quite fulsomely and describes it as shocking levels of collusion in this case, right? So the Prime Minister is admitting to this and offers a very fulsome apology. So then, of course, media cut to Geraldine, to the wife, and says, what do you feel about this? How do you feel about the apology? And she says, straight to your point on truth, she says, well, I can't really accept this apology because he's not giving me the tools to get to the truth. Because you're apologising for what you're doing here is Prime Minister Cameron saying, I'm terribly sorry about the shocking levels of collusion, but I can't tell you what those shocking levels of collusion actually are. And so she wasn't accepting of it, you know, and I think she was right. And I think it was apology being used in a very clever way, in an obfuscatory fashion, because he was refusing to set up a public inquiry where the evidence could be cross-examined. Now, Labour have now set that up, and so that will go ahead. It's tricky, this stuff, you know. Other families might have taken a different view on that. She has been determined, that family had been determined, her sons, the whole family, they were sitting around a dinner table on a Sunday night having dinner when the loyalists came in and shot him in front. She was wounded, the children were all witnesses. So all of that family have been involved in that case forever, and she has been determined that they will have a public inquiry, and truth was more important in that case than the apology or the acknowledgement, you know. But others might take a different view, you know, Bloody Sunday families are different. It's a tricky one. Certainly, if it looks like you're using an apology to stop families getting truth, it won't work, I think, would be my instinct.
I see 2 Nick, and 3. Okay. Maybe we should cluster these.
Sure, yeah. Okay, I'll cluster.
Yes, so thank you very much, Professor. So my name is Alberto Lopez. I am a fellow in the Center for European Studies and assistant professor in the Free University of Amsterdam, a political scientist. So my question is, in a way, a follow-up from the previous question. Because my question is on, you mentioned this, you know, the staticity, whether it can be static or not, like the view of the victims, yes, regarding the apologies. And I ask this because I have a feeling, I come from the Spanish context, I have a feeling that, at least in the Spanish context with ETA, is that there was a moment in which a majority of victims kind of like accepted, you know, the set of apologies that were provided, but with time, this acceptance has been perceived as more limited in the sense of, okay, they can participate in the political process. They can they're you know, like the more pacific political parties. They can participate, but they cannot form government. They cannot form coalitions. So I wonder, you know, how you know, this dynamic process between
the unionists used to refer to this as a decontamination process. With regard to Sinn Féin, they would talk about a decontamination process before they could be in government. You know. So anyway, sorry to cut across.
No, so
very similar. Yeah.
So basically, yeah, I wanted to know about your experience in the Irish context and this decontamination process and how it informs, you know, the acceptability of the apologies.
That I can do. Very interesting. Okay. I'm clustering. So there was 2 others. Yeah.
Yeah, my name is Jackson, a PhD student here at Harvard, political science. 2 quick questions. One goes back to the question about the base as well, of the armed groups. Specifically, I mean, you mentioned the possibility of pushback from the base if they don't like the apology. But I'm curious if you saw evidence of sort of when the leaders do the apology, it sways the base to become more understanding or more accepting, I guess, of their potential culpability in some of these incidents of violence. So I'm just curious if you see that kind of positive top-down influence.
Okay.
And then my second question is, in your experience, does the potential political ambitions of some of these non-state armed group leaders play into this at all? So it sounds like from the Northern Irish context, one of the leaders you mentioned ended up becoming, you said, deputy minister.
Yep.
The other cases I know well in Indonesia, certainly in northern Indonesia, the armed groups after a peace treaty ended up becoming members of the government and state. Like, so is there potential future?
It's a scam or?
Scam, exactly, I'm just curious if you saw any dynamics with regards to their political ambitions.
Thank you. And I had one other one. There's another one.
I'm Ruby, and I'm also a PhD student in government. I had a few questions, but feel free to answer whatever you're interested in. One question was actually going back to the original point about beyond legalism. And so I know you pointed out, like you saw, seeing the law as a stick as being a problem, but I was wondering if there were other things other critiques you maybe initially had about using the law as a tool for change in this context.
Okay.
A second question that I had was about like the long-term changes. So I know you were saying that Northern Ireland is towards the maybe tail end of this process.
Yeah, absolutely.
But I was still wondering about what other, I don't know, changes or things you would want that society to still have in place to prevent something like this from happening. And then the third question was kind of related to some of these questions about the organizational base itself. And like, I think in one of the slides you talked about thinking about that organization's sense of self and appealing to that. And so I guess there's a balance between appealing to their sense of self, but also maybe getting an I don't know, like where you see that balance coming into
So
play.
organizations. Great. Thank you all. So first of all, ETA, victim acceptance, decontamination. I've done a lot of work in the Basque Country over the years. As you know, there's a lot of traffic back and forward from Northern Ireland to Basque Country. I mean, I suppose the first thing is that it's always struck me how strong an influence the victim sector have on politics in Spain in terms of how to address legacy matters. Not always for good, but I remember being in the Basque Country at one juncture, and the press were running a story, Friends of ETA, and these were people who were attempting to help facilitate and it was Tony Blair and Bertie Ahern and stuff. It was like, this is bonkers, you know. But anyway, the politics of victimhood in the Spanish context is very interesting. That specific language would have been used by the right within unionism as part of the early stages of the transition, and it was rightly faced down by the Irish and British governments, which basically said if people have an electoral mandate, they're entitled to go into power. Full stop. Now that was just it, like, because we were in a process where you were trying to persuade the IRA that give up the armed struggle because you can achieve more politically, but if politics is blocked, if you're saying, well, no, that's not enough, actually we think you're not fit for government for another 5 years or something, how do you possibly persuade people to give up the armed struggle? So politics had to be seen to be working, and so the British and Irish governments. Now there were periods where it was very difficult. Decommissioning in particular was a very, very difficult thing to achieve, and rightly the British and Irish did not insist on putting the decommissioning of weapons as a precondition for Sinn Féin to go into power, because it would not have been achievable at that juncture. So there was always a very interesting and nuanced approach on the part of the two governments to these issues about, in effect, what they were doing was, and I'm sure it was based on intelligence, about helping Martin McGuinness and Gerry Adams to bring the Republican movement with them to manage the base. And I think the British and Irish broadly handled that very well. It was a very difficult process, but they were not unsympathetic to the efforts of Adams and McGuinness to transition the armed group into an exclusively political movement, and recognise the risks that they were taking, that they could be shot themselves if they lost the base. And so that argument around decontamination, it was used, I remember Ian Paisley using it as language, very similar, and it was faced down, basically. It was, the argument became, if you have a mandate, then you're entitled to power. Basically, that's it. Fundamental principle of democracy. But we can chat more about that because I'm very interested in the Spanish context. Can leaders take their base? The challenges of leaders taking their base with them. Yeah, this is really interesting, you know, because, and it links to this previous question around. I think one of the really interesting things that Adams and McGuinness showed with their own leadership of the Republican movement, they were both super cautious, actually, about stretching the base and recognising where the base was being stretched. And at times that was probably very frustrating for the governments and for others who thought you could hurry them up a bit here, like, you know. But I think they were schooled in an awareness that at every stage in Irish history there had always been a split between the politicals and the military, and they were determined to bring as many of their people with them. And so the crafting of apologies would have been shaped exactly like that. So that, I know some of the people who were involved in that 2002 statement, and they were super conscious of that, about not alienating the base through, so they were under pressure to issue an apology, and some civil society actors who had a great deal of respect within the Republican movement were encouraging them to issue that statement. and they could see how it would be politically useful at the time, but they were super conscious that this is a challenging thing for the base. So yes, I think leaders can bring the base with them, but they have to have a very cautious, nuanced approach to it, and apologies are right at the core of that issue. I think they're fundamental. And your second question about absolutely, it's linked to the political ambitions of the group. So in the context of Irish republicanism, they wanted to be in power. They wanted to gain power. They recognised that certain things were going to have to happen for that to happen. The end of the armed struggle, the decommissioning of weapons, and arguably engagement in dialogue around apologies and addressing the past. Interestingly enough, this goes back to actually my colleague from Spain's question. So in the early days of the Republican movement's approach to legacy, they were in favour of, we'll have an amnesty and we'll have a truth commission like South Africa. So, very strong links between the ANC and Sinn Féin, the political wing of the IRA. So we'll have the same as this, we'd like the same as they did in South Africa. What happens, however, is victims of state violence, for example, the Bloody Sunday families, are saying, whoa. Hold on a minute. Now, and many of these will come from a Republican background. Hold on a minute. So you're telling us that the British, the soldiers who are responsible for Bloody Sunday would get an amnesty? Are you kidding? And what happens then is, so then the other party within the nationalist community, which is called the SDLP, they go hammer and tongs against the Shinners, Sinn Féin, on this point, saying McGuinness and Adams are lining up with the British to secure impunity for British soldiers. And so the victims tilt the axis within the Republican movement. So initially having supported an amnesty, then you have a Republican movement, which, Republicans, you would expect them to think, well, an amnesty is a good idea because we don't want any of our people going to prison. But actually what happens is the victims of state violence tilt the axis within the Republican movement and they go, okay, that's gone. Amnesties are gone. We used to like amnesties, and that's what happened. And partially it's politics because the SDLP were making, Sinn Féin could not have victims of state violence lining up with the SDLP within nationalism against them. They're all, so that shows again, back to your point, the power of victims. Okay, the beyond legalism critique, a few people have asked me to go back to it. It was 2007 that I did that. I think I will actually, but I'm afraid I might look like an apologist for lawyers now. Because I think partially it is what's happening in the world where you think there are only certain institutions where authoritarian power is checked. And courts are a good one, and lawyers and law firms stepping up and doing the right thing are a good thing. And it's the same in the transitional justice context, where I suppose having spent my colleagues and I worked very hard on taking on Boris Johnson and his amnesty, and the courts were central to that. So we worked very hard, for example, at getting the Irish government to take an interstate challenge to the European Court of Human Rights against the British on this. We worked closely with law firms and victims to litigate in the domestic courts. So we were law. And a few colleagues did point out, going, aren't you the anti-law guy? What will all happen? Anyway, I think I might revisit it because I'm not sure I got it. I'm not sure I got it all right. In terms of your other question about the non-recurrence, absolutely. The key thing in all of this is non-recurrence, as I said, is probably the least developed of the pillars of transitional justice. But in our context, we needed to establish political institutions that had credibility, which broadly, our assembly's been up and down, but broadly it's working, inverted commas, small w working. But absolutely crucial again, and this goes back to law, was we needed to have very firm human rights law as central. Part of the origins of the conflict lay in the civil rights movement and lay in people's rights not being respected by the state. And therefore, we had to ensure that the structural changes happened, that we had strong, enforceable human rights laws that people could point to and say, no, we had to have cops that the community could have credibility and trust in. We had to have a judiciary that people had credibility and trust in. And we sort of have achieved all of those things, and those are very firm aspects buttressing against non-recurrence in our context. So while in this talk I obviously have been focused on the non-state armed groups, that is all within a context of major structural and political reforms as well.
Yes, thank you again. Natalie, I'm a PhD student in the Department I have just some follow-up questions on
Sure.
some of the other discussion points, mostly around kind of sequencing and timing.
Mhm.
So one is on, like, the case of Northern Ireland, their, like, transitional justice couldn't have been incorporated into the peace process, but in other cases it has been.
Yeah.
Like, is there anything that you've seen in the comparative work you've done that indicates kind of what might lead to, like, the timing when transitional justice is ideal? And then just a question, I don't do much work in transitional justice, but so, like, how do you identify when a process is, like, done or near done? Like,
When have you transitioned?
yeah, yeah, exactly. Like, if the Northern Ireland
Yeah.
process is close to completion, like, how do you determine that that's been successful just for
Okay.
someone outside?
When is the transition done? That's a great question. On the sequencing of the deployment of transitional justice, it's very context specific, I think. And as I said, in other contexts, e.g. Colombia and South Africa, and in most places, actually engagement with transitional justice as part of political negotiations is part of it. It's a norm. It was just the reality of our context where partially it was also about language. Here's a good example so my colleagues and I, we're schooled in transitional justice, and we use language of transitional justice, and we talk about armed groups, and we use that language, international language, international humanitarian law. That's a total turn-off for the unionist political actors in our context. And so when we were, during the negotiations in Stormont House, my colleague Louise Mallender and I were working hard on trying to come up with a design basically for the limited immunity mechanisms that I've been describing. And of course, when we're in meetings and stuff, we wrote a lot of papers. We said, oh, they did this in Argentina, and they did this in Chile, and did this in South. And you're thinking, it's getting no traction at all with unionist political parties. So they just don't like all of that stuff, because partially that's about accepting that there was a conflict. Partially that's, if you use international language or in conflict, you're accepting there was a conflict, which politically and ideologically for unionists at that juncture was a harder sell. So anyway, so we're coming up with the transitional justice, techo, nerdy language. Anyway, I remember saying to my colleague, Louise, we are barking up, I actually phoned her late at night, I think, and said, we're barking up the wrong tree here. I know why we do this. This is how we do this, right? We say, forget all the transitional justice fancy language, forget Chile, Colombia, all that. What this is, Margaret Thatcher once famously described Northern Ireland as being as British as Finchley. Finchley was her constituency, and she once, completely wrongly, described Northern Ireland as being as British as Finchley. And so I said, well, no, what we got to do is, this is as British as Finchley. See this limited immunity stuff? British as Finchley. And what? Well, phone me tomorrow. Right, okay, so anyway, so what I did was I went back and I looked up all of these inquiries that had been established into trains that crashed or boats that sank. I found all this, British public law, legal traditions, the privilege against self-incrimination in public inquiries into a ship that sank in 1907. It's there, and it's the print that I went into the law library and I dug out a dusty book called The Salmon Principles of blah, blah, blah. And so then, so never mind the fancy language of transitional justice or all that, we were framing it as, no, this is British. This is, look, here's Lord Justice blah, blah, in this boat that sank in whatever. And you have a privilege against self, so anyone involved in a process like that. And then we were in business. And it wasn't just the sequencing, it was the language. It was like, well, if it's British, if it's good enough for Lord blah blah in 1906 in a boat that sank, this is what we're doing. And so you're taking the heat out of, so it wasn't just the politics and the practicalities of the sequencing, it's actually the language. So we stopped using it. We stopped using transitional justice and we just used British legalism. And that was much more palatable, and ultimately the unionists agreed to it. So that was sequencing and language. And when is the transition done? I get asked that all the time, and I never have a good answer for this. I suppose in our context, what I would say is that if you have stable political institutions, if you no longer have serious levels of political violence, and if you have credible legacy mechanisms that have addressed the past, I think that looks to me like you've finished your transition. I mean, not everybody would agree with that in the field, but those kind of feel like the right sort of benchmarks to me. If you ask me that again, I'll probably give you a different answer.
Any other questions? I mean, I have a lot of questions, so I think I'm going to probably hold most of them and just ask you later. But maybe I will ask one of the 3 or 4 I have, which is I'm very interested in the motivations for undertaking this on the part of non-state armed groups. And you've articulated some theories, and some of your answers to these questions have articulated some arguments. So I've got a whole list of potential explanations, partly based on what you said and partly what I've been thinking. So that's one question. But before I even raise those, and maybe I don't have time to raise those in the 4 minutes we have left, I'm wondering whether there are differences in individual level versus like the armed actors who perpetrated the acts, because some of your examples are individuals apologizing versus organizations. It seems like there's 2 different levels of analysis here. Maybe you're more interested in the organizations than the individuals. And if we're more interested in the organizations, do you find that organizational structure, governance, hierarchy matters? Because I'm thinking about, in the Northern Irish context, Sinn Féin is much more hierarchical than some of the other parties. It seems like they're very on message. So is it a different kind of dynamic getting them on board than one of the others, or does the organizational hierarchy not really matter?
Great questions again. On the individual versus organizational, you're right. I'm more interested in the organizational. In fact, one of the bits of the definition there that I offered up is that I'm interested in public apologies and public apologies that are authorized, where a person is authorized to speak on behalf of an organization or a movement. And so there's a role for individual apologies and reconciliation work and so forth, but that's not my focus. Why they do it? Legitimation, politics of transition, respectabilization. I also think, and this has been videoed, there's something else that I haven't written about that I think is also going on here, is that in my experience, so I've written 2 books on prisoners and former prisoners, people who've been involved in armed actions. I've done hundreds of interviews with former combatants. I have met very few people I would describe as abnormal. Most of who I'm not a psychologist, but anyone who they seem perfectly normal people to me, and so who were engaged in often horrendous acts of violence. And so there's something quite interesting here about some of the people who are providing the most leadership in the armed groups community, in the former combatant community, are serious people who have thought deeply about stuff, probably thought deeply about their past actions, and are arriving at a place where they're wanting to address the past, and they want to make sure this doesn't happen again. They're thoughtful actors. So there's a moral dimension to people. So this is, I don't want to overstate this, but there's a moral dimension to people who were engaged in past violent acts, wanting to deal with that at an organizational level. So wanting to address that's as a moral act. And I think that's, when I said earlier on about you're looking for the sweet spots to figure out a way to try to nudge people towards doing the right thing. I think that's one of them, Melanie, is that most of these people in their late 60s, early 70s, grandchildren, all of that. I think that this is part of addressing the hurt that we inflicted on each other in our society, and there's a moral leadership dimension that's happening at the moment. And part of the impetus to get this done, they're getting older. Victims are getting older, and ex-combatants are getting older. And if it doesn't get done now, there aren't the same people around who have that credibility. It definitely, your point on Sinn Féin being very organised and bureaucratic, absolutely right. And so once they make a decision, it's like a tanker, and the tanker's pointing in a particular direction. But in fairness, and that's why I've highlighted the loyalists here. As you know, the loyalists are very disparate. Some of them have morphed into criminal gangs, and yet there is still a core of people in certain bits of loyalism with whom one can do business, and who I think are moral actors who wish to address the past. But you have to be realistic about that as well, and part of that is, as I said earlier, I think be pretty cold-eyed. So if you're talking to a victim who was affected by this group, not this group, you just say that crowd have become. There's no one credible that you could do business with in terms of addressing the past. So I wouldn't want to lead you up the garden path. But if it's, for example, if it's the leadership of the UVF, probably there are people there who that could be done. That might look different with the UDA. It'll look very different with the LVF, the INLA. So different groups. It's a pretty cold-eyed. approach to which groups you're dealing with and what they have in terms of political will and capacity. But it's still worth doing, and I've been stressing this to colleagues in the Northern Ireland office. If, for example, you were saying that we're only really going to get engagement on information retrieval from former IRA and bits of the UVF, they still killed 2,300 people between them. That's a lot of people, you know, so potentially that's still a lot of people who could get some good out of that, you know. So even if you say the rest of the groups you won't get much, that's still worth doing. If those are big, important players, you know. So.
I think on that note, thank you so much. We're out of time.
Okay, thank you.